going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everyone doing? Hope you're having a great night so far. Happy Sunday. Oh, wait a second. Hold on. Hi, everybody. Happy Sunday. Let's go. Hopefully, you guys had a great weekend. I've got a fun clip tonight. It's one case. We are doing a full preliminary examination with Judge Flores. I kind of teased it a little bit on Friday. I wanted to play it Friday, but just a little bit too long. This might be a two-parter. We'll see. We'll see. It's a long one. It's about 2 hours long, so probably gonna be a two-parter, but we'll have fun with it. We'll see. Anyways, good to see you guys tonight. You want to watch some court? I want to watch some court. Let's watch some court. My phone's going off. I forgot to mute my phone, so I'll do that after my intro. Before I hit that play button, you know what to do. Hit the like and subscribe to your Jump Kick Backflips. Let's go.
Go on Mr. Brangman. All right. So we're on the record in 26-01352. That is People of the State of Michigan versus Edward Justin Brangman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Bood.
Andrew Bood on behalf of the defendant who's here and seated to my right.
All right. And sir, you are Edward Justin Brangman. Is that correct?
Yes, Your Honor.
All right. Thank you. This time set for a preliminary examination today. Ms. Fortuna Gill, it's my understanding we're having a preliminary examination. How did you want to proceed?
Yes, Your Honor. It's also my understanding we're having a preliminary examination today. The people are able to proceed on the preliminary exam today. I do want to place an offer on the record. There was an offer extended to plea to an attempt of the electronic communications. That would have been a 1 year, and a domestic violence, the 93-day, with a dismissal of the remainder of the charges. That offer does expire at the beginning of this preliminary examination. Additionally, is the people's intention, based on incoming testimony, to either increase or add charges at this preliminary exam? I do just want to make a clear record of that.
All right. Is that your understanding, Mr. Booth?
Well, she did offer the 1 year, and then apparently she talked to Joel Martinez and apparently revoked it, then claimed she didn't offer it. I'm not sure.
How am I trying to do that? I don't know what you mean. No idea what you mean. I'm here. Look, see.
All that on the record.
Okay. I think it's just kind of a CYA.
Apparently, she wants to penalize the defendant for exercising a right to a preliminary exam, but we intend, since we're talking about what we're going to do at the end of this, to ask for the charges to be dismissed, and if anything is bound over, we're also going to ask that the bond be modified so that he can have contact with his kids. And I think you're going to find that whatever happened here, there was no intention to commit any type of harm to the children, and he should have contact to be able to see his kids and exercise parenting time.
All right. Thank you. So I'll await to hear the proofs on the matter. There's one witness, Mr. Anderson's here, so I know he's with the Abood Law Firm. I don't know who the other witness is. So I'll invoke the sequestration order.
Okay. We only have one witness, Your Honor.
Okay. Are you Mr. Wilkinson? Yes.
I'm Rick Paul from Mel Witness. Wilkinson.
All right. So I'll invoke the sequestration order. So no witness should watch another witness testify if that plans to be a witness. But counsel knows the case better than I do, so you'll let me know if I need to invoke the sequestration order or not. This is a 2-count felony complaint and then a 1-year misdemeanor. Anything else to come to the court's attention before we get started today, Ms. Fortuna Gill?
No, Your Honor, thank you.
All right, Mr. Booth.
I'm real. I am real. Hi.
All right. So you may call your first witness concerning this matter.
Yes, Your Honor, the people called Jacqueline Paris.
This is Ms. Paris.
Yes, Your Honor.
All right. Ms. Paris, you can come up here.
Go up. You want that? Okay.
So you can please state and spell your first name and last name for the record.
Jacqueline Paris, Jacklyn.
Okay, please raise your right hand, ma'am. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Right, you can have a seat. The microphone does not amplify your voice, so please project as best you can, all right? And then Ms. Fortuna Gill, when you're ready to proceed, I'm going to assume that both counsel that the sequestration order can come to the court's attention if there's any witness in the courtroom that doesn't plan on being a witness at a future date.
Yes, Your Honor, there were 2 victim advocates from my office that came in with me, but yes.
You don't plan on calling him as a witness?
Absolutely not.
All right. And there's one gentleman here, and you don't plan on calling him as a witness?
I do not.
Mr. Booth, do you plan on calling the gentleman as a witness?
I don't know that person.
Okay, all right. All right. So if he's not planning on being a witness in the case, I think we're just.
Quick side note, something that happened to me today. It's because I feel like sharing, fun stuff. So Team Skeptic called me. He found a clip of a judge watching one of my court videos in court. While he's on the bench, he was watching one of my videos. You couldn't see it. So we don't really know what video he's watching, but you could very clearly hear the "What's going on? This is Colin." It made me laugh so hard. Oh, it was good. He's clipping it for me. He's gonna send it to me. So we're gonna have some fun with that. But I just wanted to share that. Kind of hilarious. Judge is talking about sovereign citizens to an intern, and he's like, "Oh yeah, I've got this one video that I watch," and he just all of a sudden you just heard clearly my intro. It's good. It's good. So Judge is watching me. Yay!
So that you're just if you plan on being a witness in the case, this may affect your ability to be a witness on the case if you see another witness testify. All right. At this point in time, it's not a problem. Ms. Fortuna Gill, when you're ready.
Thank you, Your Honor.
Can we move this so I can see them, or?
Oh, the books.
Yes.
Okay. All right. Can you please tell me, do you know, at any capacity, do you know Edward Bregman?
Yes.
Yes. Can you tell me how you know him?
We dated for almost 9 years.
Okay. And do you have any children in common?
We have 2 children, Bennett and Baylor.
And did you see him in the courtroom today?
I do see him now, yes.
And I guess I will specify because you did list your children as well. Do you see Mr. Bregman in the courtroom today?
Yes.
Can you tell me what he's wearing?
He's wearing a suit and tie.
Okay, Your Honor, at this time, I would like the record to reflect that the witness, Ms. Paris, has.
He wasn't on the record on the case. He was talking to an intern. There wasn't a defendant he was talking to. It was just they left the camera on, and it was a really good clip. That's why you pay attention to what happens in the courtroom when it's running and there's not a case, because sometimes you get some good nuggets. While I'm paused real quick, Legal Fiction. Thank you so much for the 10 gifted memberships. I appreciate it, bud. Hopefully you had a good weekend. Thank you so much. Very generous of you. Welcome to the 10 new members. Thank you, Legal Fiction.
Identified the defendant as Mr. Bregman.
Okay, so the witnesses identified the defendant for purposes of prelim concerning Mr. Bregman being the person who's sitting in that seat. Any objection to the witness identifying the defendant, Mr. Booth, for purposes of prelim?
I don't know, did she point? Because all she said was he was wearing a suit and a tie.
So that's what you said. He's wearing a suit and a tie.
Yep.
It's not the attorney who just spoke.
Correct.
Okay, it's the person next.
Congratulations, attorney. She wasn't talking to you. Really?
Next to the attorney.
He's wearing a gray or silver suit.
All right. Any
And
objection,
we'll-
Mr. Booth?
I mean, I mean, okay. But we can't say it's the person next to Mr. Abood, and then, of course, she's gonna be able to identify, but to the extent that she knows who Mr. Bregman is, yes,
All right.
that's fine, but
The-
I mean, we can't say, isn't this Mr. Bregman? And then she says yes, and then we say, okay, we have a valid ID. But
the objections noted and the witnesses identified the defendant.
Thank you, Your Honor. Further for the record, I do that Miss Paris did look and nod her head in Mr. Bregman's direction as well when she said the man in the suit and tie.
All right.
not sure that helps the situation.
Welcome to exactly how this hearing is going to go. Like I said, it's 2 hours long. It probably could be 45 minutes, but no. We got a defense attorney who's trying to make his paycheck tonight.
Okay, Miss Paris, do you recall the date of May 17th of this year, 2026?
Yes.
Okay, can you tell me what is so significant about that date to you?
Yes, that is the date that Eddie was physical with me.
Okay, and when you say Eddie, are you talking about Edward?
I am.
Okay,
I refer to him as Eddie.
okay, and that's fine. I just want to make it clear record. And you said he got physical with you. Were you at home or somewhere different?
At home.
Do you have the address?
Yes.
Can you tell me the address?
2410 Robinson Road, Lansing, Michigan.
Thank you. And is that in the state of Michigan,
Yes.
county of Ingham?
Yes.
And can you tell me how that physical altercation began? Was there an argument or something else?
There wasn't much of an argument.
Okay.
Not a big one. It began with me trying to put down our 4-month-old son and
Okay.
our 2-month-old son, our 2-year-old son coming.
What do you mean? I have exactly one Cooking with Colin episode, and I'm actually thinking there's going to be a few more. I wouldn't mind doing that. They're just going to be like kind of quick things, but yeah, no, that was fun. So no, well, I mean, I'm not saying legal fiction can't do beef Stewart with Stewart, but yeah, beef stew with Stewart. Sorry, I'm gonna stop.
And crying and kind of interrupting the situation.
Okay, so you have 202, is that?
2.5-year-old.
Okay. Okay.
And what's the 2.5-year-old's name?
Bennett Bregman.
And you said you were trying to put the 2.5-year-old down for a nap?
No, sorry, the 4-month-old.
Oh, okay. Can you tell me more about that?
Sure. I'm just sitting and laying in bed, like nursing him, trying to get him to sleep. And Bennett comes in the room, crying, kind of interrupting the situation. And typically Eddie is with Bennett during that time. And so I'm calling for Eddie to come help with Bennett. And then he gets Bennett.
I know.
Bennett interrupts us, me and Baylor. The 4-month-old is Baylor.
Yes. Understood.
And then I call out for him again to shut the door.
And you call out for Eddie?
Mm-hmm.
Okay.
But
Oh,
Is that a
is that a
yes?
yes?
You have to say yes verbally.
Yes.
Thank you.
Yes, that is a yes.
Because we just can't spell. Mhm.
Thank you.
That is completely my bad. Usually I inform witnesses that you can't type head nods or mhm or uh-huh. So the worst that'll happen is if that happens, someone's gonna ask you, is that a yes? Okay. Now, did Eddie come help out with that situation?
Yes, he grabbed Bennett and left. And then I asked if he could shut the door. And
Okay.
the door was slammed, and that kind of started.
Okay, so were you upset that the door was slammed?
I was frustrated. Yes.
Okay, and so what did you do?
I set Baylor down. Once he was asleep, I set him down. I went into the bathroom where Eddie was with Bennett, and I told him, you can be frustrated with me or mad at me, but please don't take it out on our children. Show that you care, meaning show some honor and show some respect towards Baylor and his sleep.
Okay, so just to clarify, the slamming of the door made you so upset Why did it make you so upset?
Because to me, it shows that he does not care about Baylor trying to sleep.
The 4-month-old.
Yes.
Okay. And after you said that, how did Eddie react?
I don't quite remember all the words he said. He said words to me. That's when I walk away, and then I hear him cussing and talking to our 2.5-year-old Bennett, saying things about me.
Objection.
So what's the nature of the objection?
I withdraw.
Go ahead, Ms. Fortuna, go.
Okay, so when you hear Eddie, what is it that you do?
That's when I go into the bathroom and I say, don't you ever say that about me to Bennett again.
Okay. And did you physically do anything at this point?
I splashed water, or I flicked water in his face. Because like he's like yelling at me when I say don't ever talk about that, or don't ever talk to Bennett about me like that.
Okay.
And then he's saying like get away, or like I don't remember.
That's okay. That's okay.
We're starting to have this type of verbal argument.
Back and forth.
Mhm.
Okay, understood.
So
And
yes.
so
Yes.
and then at some point you flick water in his face. So how is it that
Flicked, I think is what she said, not flick.
Flicked.
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 flicked water into his face? Can you tell me how the water got onto your hands?
Water was running from the sink,
Okay, so there's running water.
and we're in the bathroom, and there's already running water.
Understood, thank you. And how is it that Mr. Bregman reacts when you flick?
All right, so you're arguing, and you threw water in his face. Didn't we just watch a case yesterday where that happened? Well, yeah, kind of. Just saying. Just saying. Eh, And I don't think that water should be considered assault, but courts do. It's considered assault. Throw water at somebody, especially in the heat of an argument. That kind of sounds like escalation in my book. I don't know. We'll see. We'll see we'll see where this goes. This happened like 2 weeks ago. I don't really remember too much of this case, so I feel like I'm watching it for the first time with you guys. I remember the end. I remember what happens at the end, but I don't remember the entire thing.
Water into his face?
Mad. He was angry.
You got angry? Okay. And when you flicked water into his face, did you actually physically touch him at all?
No.
Okay, so and about how much water do you think it was?
Less than a spray bottle.
Okay.
Very much so.
Okay.
So I am so sorry, Dr. JD. I just paused it. I didn't thank you for your 28 months. Thank you so much, Dr. JD. I appreciate it. Thank you so much for the support. That is awesome. Thank you. Someone also made another comment that was kind of funny. Hold on, where was it? Where'd it go? Where'd it go? I don't think that was it, but maybe that's what I laughed at. Maybe it was the salt water. All right, we'll go with that. We'll go with that. Hey, Bill.
And can I ask, was your intention at that time to hurt Mr. Bregman?
I'm just gonna put on the record that she's essentially confessing to an assault, and she probably ought to be advised of her rights to remain silent. And her intentions.
I don't think I don't think the prosecutor plans on I think they've had this discussion as part of the proofs. So it's noted for the record that this witness is indicating that she may have been involved in the offense of touching, but we'll go from there. Ms. Fortuna, go.
Thank
But
you.
I'm not sure she's been advised of her rights to remain silent, and I'm not aware of any immunity agreement that this witness has.
Neither am I. Ms. Fortuna, go.
That is correct. There is no immunity.
Oh yeah, absolutely, absolutely. I don't really remember this case through and through. I remember the defense attorney objects to a lot. His questions to the witnesses are a little extreme. That's what I remember. That's why I'm playing this. And again, I remember how it ends. I don't remember the facts throughout this case, though. I don't remember the specific charges, just to be honest. So, yeah, I'm just saying, don't throw water at people because it's considered assault. But which is what the defense attorney just said. I don't think flicking water is assault though. That's I'm just saying don't do it was my point. But thank you, Georgia.
Agreement. It's also correct that my office does not wish to proceed on any sort of charges coming out of these facts.
You may proceed.
Thank you, Your Honor.
So essentially, she has immunity. Sounds like.
I don't know. It's not my charging decision. Go ahead, Ms. Fortunico.
Thank you, Your Honor. Ms. Paris, can you tell me, did you intend to harm Mr. Bregman
Objection,
with
no.
that action?
Objection, no.
Response, the relevance is a fairly low standard response.
My response would be relevance is a fairly low standard. I think that it's relevant here as to what the next actions are.
I think only this witness knows what she's thinking at the time, so it is relevant. So I'll allow the question. The objection's overruled.
Thank you. I'll ask again, Ms. Paris, did you intend to harm Mr. Bregman with those actions?
No.
Okay, thank you. And did he physically harm you in response?
Yes.
Can you tell me how?
He grabbed a hold of me while holding Bennett. He was holding Bennett. Grabbed
Okay.
a hold of me.
And can you tell me where he grabbed you?
Yeah, you can maybe see still a mark. There was a large bruise here. Smaller now.
And you are pointing to your right.
My right arm just above my elbow.
Okay, thank you.
So the record reflects that she's pointing to her right arm right above her elbow.
Thank you. And what did he do after he grabbed you?
It was, he was shoving me down to the ground, so it was not a push where he like released. It was more holding on, forcing me down very hard towards the ground.
Okay, and is he doing this one-handed if he's holding Bennett?
Yes.
Okay. So then how do you respond when you're on the ground?
I grab him.
Okay,
I grab
And-
his testicles
okay. And why did you do that?
to get him off of me and to let go.
Okay. And did he let go at that point?
I think within seconds. I
Okay.
don't remember if it was in that moment or very soon after.
Okay, that's okay, but at some point he does let
Yes,
go
he does let go.
after you grab his testicles.
Yes.
Okay. Now, is that the end of the physical altercation?
No.
Okay, so what happens next?
In the middle of that first altercation, I noticed Bennett is very close to our ledge, to the staircase.
Okay,
And I say, oh my gosh, in some capacity, Bennett's face, you just hit Bennett's face.
okay.
And that kind of, that also like stops things.
So when you say you hit Bennett's face, did Mr.
I am not taking the bait there, Mayor. Nope, not taking it. We don't mention that name on the show. I'm just kidding. I'm just kidding. I'm on video. You're welcome. I don't know. Also, thank you so much for the 25 months. Good to see you tonight, bud. Hopefully you're well, man. Hopefully you're well. Thank you for hanging out with us tonight. I bet you're working. You only hang out with us when you work. It's like, oh, you're too cool for us on your off time, but when you're getting paid to watch me, it's different. I'm just kidding, bud. Good to see you.
Bregman physically hit his face or something different?
No, and holding him in the altercation, forcing me down. Bennett is then leaning forward, moving down, and it looks like his face is hit on the ledge.
Okay, and you're pointing to the right side of your face. Was it the right side of Bennett's face? Do you recall?
I don't recall what side of the face his was.
Okay, that's okay. And was Bennett injured at all from this that you saw?
So, well, that kind of plays into the next part.
Okay,
Well, how about we just answer that question?
Sure. I think so.
okay. And what makes you think so?
Because after
I was trying to point to the building. It's there. It's a bank building. A bank owns it. It's gone from bank to bank to bank since I've grew up in Cincinnati. So yeah, I'm pretty sure that show was never actually filmed on location, but maybe it was. But it's always been a bank building. But yeah, it's there. It's there. It's right there. You can't see my mouse cursor. It's like right past the arch.
Afterwards, now we're standing in the living room. I see blood on Bennett
Okay,
in that same spot.
okay. So there's blood on Bennett's face.
Yes,
And is it possible that it could have been your blood? Were you bleeding?
no, I was not bleeding.
So only Bennett was bleeding in this situation?
Objection needed.
I'm gonna sustain the objection. That's leading.
Legend has it those turkeys are still flying. Just so everyone's clear, they're still flying. They are absolutely still flying.
Yes, Your Honor, that is fair. That's okay. So, Miss Paris, tell me now, let's go into the second altercation.
Okay.
After you notice that Bennett has a mark on his face, what happens next?
As soon as I see that, I say, you did. It confirmed that what I saw was true about hitting his face. I see the blood. I said, you did hit him, or he did hit his face. And then with an open hand, I instantly hit Eddie in the side of his face.
Okay. And how did Eddie respond to that?
That's when he grabbed me again.
And did he grab you? Sorry to cut you off. Did he grab you in the same location or somewhere different?
Similarly,
Okay, you're not sure exactly where, but similarly on your arm?
I feel like I'm part of the chat tonight. I am not paying attention to the case whatsoever, and all I'm thinking now is that the Thanksgiving episode that Dr. JG just brought up. I am not laughing at this case. That is not what I'm smiling and laughing at. It is the chat. Just so everyone is watching this later who doesn't see the chat, I'm not laughing at this case. It's I I swear I thought turkeys could fly. Ah, that was such a good episode.
yes.
Okay. And so what does he do when he grabs you?
Forces me down again. And that's when I instantly feel pain in my foot, and I am crying, and I'm talking about the pain in my foot. I don't remember if I'm saying it's broken or what.
Okay. And did you injure your foot?
Yes, my first metatarsal is fractured.
Okay, so there is a fracture, and is it from that incident?
Yes,
Okay. And how do you know it's from that incident?
I did not have an injury before, and then I was thrown down to the ground, and it instantly happened. Swelling, could not walk on it.
Okay.
I also later then got x-rays.
Okay. And when Eddie throws you down to the ground the second time, is that the end of the physical altercation?
Yes,
Okay. And at any point, do you call police?
I do.
Okay, can you tell me about that? At what point are you able to call the police?
I called the police right after the first altercation.
Okay, so in between.
Yes,
Okay, and do you call the emergency number or
I
something?
call 911, and at the same time, I'm yelling at him to leave.
Okay,
I'm yelling at Eddie to get out of the house.
okay. And,
I also say I'm calling the cops.
okay, so you told Eddie that you were calling the cops, okay. And how is it that Mr. Bregman responded to that? To calling the police?
He didn't say anything about that
Okay,
in that moment. He didn't say anything. Directly afterwards is when I saw the blood on Bennett's face,
okay.
and that started the new altercation.
And were you able to make a report to police?
Yes,
Okay, can you tell me about that?
like
What
their
you said to
arrival.
them?
Oh, what I
Yes.
said to them?
That would be hearsay.
I think So objection, hearsay, response.
Your Honor, I don't believe that it would be hearsay. It would be, I think it would fall under an excited utterance exception here.
I haven't heard anybody as excited at this point, so I'll
That's fair. I can
lay
lay the proper
foundation on
foundation.
that. So the objection sustained.
Thank you. Ms. Paris, can you tell me how it is you were feeling in that moment when you called police?
Scared.
I mean, let's just get the record. She called 911. Is that what we're talking about? I don't think she ever called the police.
We're talking about 911.
Okay. So this as to the 911 call. Ms. Fortuna Gill, I'll allow you to go forward concerning your questions. And then if you want to confirm later, I don't know. I'm not going to tell you how to make your case or how to, but
I don't have an objection to the 911 call.
what's your objection? The
Her
nature of it?
objection was, what did you say to the police?
And
Which
I
is
sustain
much-
that hearsay
Which
objection.
is much later, but I don't need a foundation for her making the 911 calls.
Okay, all right.
I understand the misconception. I am referring to the 911 call. I will be more clear for the
All
record.
right, all right. With that understanding, Ms. Fortuna Gill, you may proceed.
Thank you. Ms. Paris, can you tell me about the 911 call that you made? What is it that you said?
Can someone please come to my house, 2410 Robinson Road, Lansing?
Okay, and did Mr. Bregman do anything while you were making that 911 call?
Yes.
Can you tell me what?
He grabbed the phone,
Okay,
hung up on them, and he threw my phone onto the kitchen table.
and were you able to call back?
They called me back.
Okay, and what happened when they called you back?
I answered.
And where was Mr. Bregman at the time?
I don't remember if he was in the kitchen or in the basement. He was going back and forth.
Okay. I have no further questions for this witness at this time.
All right, cross-examination, Mr. Abood.
Yes, just a minute. You indicated on direct examination, that's when Miss Fortuna Gill asked you questions, okay? That's what direct examination, this is cross. Follow me?
Do you remember 5 minutes ago when the prosecutor was asking you questions? Okay, we're on the same page. Let's go. You're off to a great start, defense attorney. You're so good right now. You got her. You got her nailed.
You indicated that the reason why you know or remember May 17th is because Eddie got physical with you.
Yes.
You got physical with Eddie, true?
No.
You never did.
If I would not consider flicking water being physical. So based off of that belief, no, I did not.
Do you have some kind of unique definition of physical?
Hands on someone?
Okay, you put hands on Eddie.
Objection, Your Honor, is there a question?
Yes, that's it.
The question is, the question would be, did you, I guess that it was not indicated in the form of a question, but the question was, you put hands on Eddie, and that's a question. I'm assuming it's a question mark.
Hit that like button like a disco ball. Just make sure it's lit up when you're done. But yeah, you can. Good to see you tonight, Sally.
At the end of that. With that understanding, the objection's overruled, and you may answer the question whether you put hands on Eddie.
Thank you. Is your question first or at all that day?
Stop. My question is, didn't you put hands on Eddie, true?
On that day, I did.
Yes, you got physical with him, true?
True.
And in fact, you got physical with him before he got physical with you, true?
Not true.
Okay, you flicked water on him?
I did.
Yes, you don't think that's physical?
I don't.
And you said it didn't hurt him, right?
Correct.
Physically, right? That's what you meant. It didn't hurt him physically. Isn't that correct?
We are talking about being physical, yes.
Ma'am, these questions are all different. What you meant when you said you didn't hurt him is that you meant you didn't hurt him physically, true?
Yes, that is true.
Right, you meant to embarrass him, correct?
No,
Oh, you didn't? It was a joking, loving flick of the water into his face?
also no,
Right, you meant to embarrass him. True?
no,
You were getting even with him
no,
because you were mad. You were mad. I mean, yeah, that answer, you know, in your heart, you know the answer to that, but we'll wait for you to pause and think about it. Go ahead. Let's see how long it takes for you to remember how you felt when you went into the bathroom unprovoked.
Objection, Your Honor. At this point, it's gotten argumentative.
It's a little bit argumentative. If you can answer, what were you thinking at the time?
My question is, you were mad, weren't you?
I was frustrated.
Okay, and in fact, Eddie had said something to Bennett, isn't that true?
That is true.
And you heard him,
Yes.
and you know, sitting here today, what he said.
That's actually not,
Oh, really?
I don't remember those exact words.
He didn't say your mom's crazy or something to that effect?
I did not say that. I don't know what he said.
You don't remember?
No, I remember what he said really angered me, and that to a point where I believed he should not talk like that in front of Bennett.
But you can't remember it now.
No,
Why not? You told the police.
I don't remember.
Objection, Your Honor. I don't know how she's supposed to answer how she doesn't remember something.
I believe
That's
she
like
said she doesn't remember, and that was the answer to the question. So the objection.
All right, I will say this. I appreciate a defense attorney going all out for their client like this. I appreciate this. But when the charge is domestic violence and kind of battering the wife as an attorney on the stand, he's, borderline badgering her. I don't think that's a good approach. We just saw this in a video with Judge Boyd. I don't like the approach. The the alleged victim is going to get very defensive on the stand, and it's not a good scene. That being said, the defendant, the guy, deserves a defense, and I don't hate the idea of standing up for him, but I just think it needs to be done with some class. I don't like badgering, especially in a domestic violence case. I don't like it.
Sustained.
Did you give a statement to the police?
I did.
Did you review the report?
I did.
When was the last time you reviewed it?
Roughly 5 to 7 days ago.
So you don't know what he said, but whatever it was, it made you mad.
I knew at the moment what he
How
said.
about just to answer my question?
I don't understand your question.
You don't know or remember what he said, but whatever it was, it made you mad.
Yes,
And you were in the bedroom with Baylor, right?
yes,
And Eddie was taking care of Bennett. Again, we have a long pause. True?
I'm pausing, so I'm not sure I would consider it taking care of Bennett.
Well, was he washing Bennett's hands? Yes or no?
Yes,
And wasn't the water on?
yes,
And hadn't they been outside and he had bug spray on him?
I don't know.
Okay, well, would that be a reason to wash your child's hands?
Absolutely.
Okay, so you wouldn't have an objection to Eddie washing Bennett's hands if he had bug spray on him?
Correct.
And so if that's what he was doing, and it was in the bathroom, there was nothing inappropriate about that, right?
Bennett was crying out while washing his hands. And when I walked in there, Bennett reached for me.
I don't know what you're talking about. My question is, if that's what Eddie was doing,
Uh-huh.
washing Bennett's hands after he had been outside and had bug spray, there would be nothing inappropriate about that, right?
There is nothing inappropriate about washing Bennett's hands with bug spray.
Okay. And in fact, that bathroom is very narrow, right?
Yes, it's a small bathroom.
And there's a sink in the middle, right?
No, it's all the way to the left.
Okay.
Oh, that's downstairs.
This one?
These are downstairs. Two are downstairs.
Is this the bathroom? right here?
No, that's downstairs.
Show this. May I approach?
You may.
Is this the bathroom that the two of them were in?
Yes,
And you felt the need to go into that bathroom?
yes.
And tell me where Bennett was relative to that sink.
Right in front of it,
Was he standing or being held?
being held.
And who was he being held by?
Eddie,
And if Bennett is right in front of it, we'll say on center, then where is Eddie? To the left or to the right of Bennett?
that would depend on how, if he was holding him on his left hip or right hip or in front.
I wasn't there. You were. Where was Eddie relative
I don't
to,
remember.
you don't remember? Okay. And then you walked in there, correct?
Yes,
And were you the one closest to the doorway?
yes.
And how close did you get to Eddie?
Close enough to reach my hand into the sink?
Okay, well, were you touching him?
No,
Your body wasn't touching him.
no.
Was Bennett in between you and Eddie?
When Eddie turned towards me, yes.
Okay. And where was Eddie when you flicked the water?
No, because he's not ineffective. He's not hurting his client at all. He's doing his best to approach, and he's, you know, I am fairly certain this is a retained attorney, so they've gone over this defense, and he probably hired this guy in order to kind of like drill her on the stand, and the state called her, so she opened herself up for this. So it's there's nothing going wrong here. I don't like it. Most people don't like it. It's hard to watch, but yeah, there's nothing wrong here except for, you know, morality, I guess. Like I said, it's like the Judge Boyd case the other day. The attorney was just going off on the witness. They're trying to catch him in a lie, right? So they ask very pointed questions. If they hesitate to answer, they're going to call him out on that. They're trying to catch him in embellishing the story, is what they're trying to catch him in. Which you want that. If you're charged with domestic violence and you believe you're 100% innocent, you want a guy like this defending you. But it doesn't make it hard to. It doesn't make it any less hard to watch. Mayor, thank you so much for the 5 gift memberships. I appreciate it. Welcome to the 5 new members. Thank you, Mayor.
Into his face.
Standing in the bathroom.
Okay, I got that. Was he to your, in front of you? Next to you?
He
Or
in
was
front of me.
Bennett in between?
Sorry, are you asking when I flicked water in the face or when I first walked in there?
Either one.
He was in front of me. Bennett was in between.
Okay. So can you mark where Bennett was on that picture?
It's not 3D, that's kind of tricky.
Well,
If
it's
I-
a piece of
if I
paper. I
mark it
agree, it's
here-
not 3D.
If I mark it here, looks like he's on the toilet, but that's not where he is.
I got it. And then that's where Bennett is? Yes or no?
Yes,
And you've marked an X?
yeah,
And is he being held over the sink? Is that how he gets his hands under the water?
yes.
Okay, so he's being held. Now, my question is Eddie closer to the toilet or closer to the door, or is he right behind Bennett?
I'm not sure. Sometimes we hold him on a hip, which would.
I'm not talking about sometimes, I'm talking about.
I
on May
don't
17th.
remember.
And so you came in and you blocked the doorway?
I did not block the doorway.
And you flicked the water into Eddie's face, how many times?
Once.
And how much water did you say it was?
I said it was less than a spray bottle.
Did you measure it?
Nope.
Did it get into his face?
Maybe. I don't know. I did not see water on his face afterwards.
Okay. And then, did he walk out?
No,
Did he try and walk out?
no.
So.
Why did you not pack any clothes? That so many different references in the stream tonight. Now you get to actually see what my face looks like when I'm reading your guys' comments. It's not good on this serious case, but yeah, maybe that's why I'm not on video very often. I don't know. Oh, great reference though, legal fiction.
Is this the same bathroom right here?
Council showing a picture of the bathroom and asking if that's the same bathroom.
And
Yes,
that's
it
where the three of you were?
I would say I was more in the doorway area, just outside of it, just inside of it at times. Yes.
Okay, you were close enough to the sink to flick water in his face, right?
Yes, I reached my hand into the sink.
Yeah, and your arm is just the same length on May 17th as it is today,
Yes,
right? So you would have been within a foot or two of this water, right?
yes,
Which means you would have been, and you had your back to the doorway, right?
could have been my shoulder
How many times have you flicked water in Eddie's face?
once.
That was the only time.
Yes,
So you're saying Eddie didn't take Bennett out?
Dan, question, since you're an attorney, when you go to cross-examine a witness, I know you're a civil attorney, you probably don't do a lot of cross-examinations, but you still do some. Do you have every single question you want to ask written down? Do you go through it in your head, like this is the game plan, these are the questions, or do you have an outline? This is the narrative I want to get released. So I'm going to ask this question. I'm going to follow up to try to get the witness to say this point. Oh, you do. All right. So is a lot of the questions, just kind of fly by the seat of your pants, like you're trying to get the witness to say one thing, to admit to one thing, or is it very scripted? Hold on. Try to script all my questions with something. Yeah, I feel like a lot of times you can, like, right? You don't know how they're going to answer specifically. Like, you kind of have an idea, but you don't really know. So that's why I was wondering, like, do you have an actual like outline, or is it a script? So you answered it. Thank you so much. I'm asking because this attorney seems to be just kind of going by the seat of his pants on some of these questions. Like, I feel like he's got a point he wants to make, but he's just asking questions that sometimes don't really even matter, just to try to get a response of some sort. I don't know.
The bathroom then?
no,
Okay. Can you tell me what this is a picture of?
So another photograph being used for impeachment purposes.
I'm not really.
Well, yeah, and I don't mean that. I mean, but you ask questions to try to get us. You want a specific answer. So if they're being, overly obtuse, or they're trying to evade, you try to get them to give you the information that you're trying to get out of them, right? But what a defense attorney is asking is pretty much based on what their client has told them and what the discovery is. So they're doing it based on that knowledge, which is one of the reasons you need to be honest with your attorney. So that's why I'm asking. Yeah, there we go. We'll let it play.
Teaching her yet, but. Can you tell me what that's a picture of?
That's a picture of living room, bathroom, doorway, hallway, Bennett's bedroom door.
Your testimony is that he then grabbed you and pushed you to the ground, right?
Yes,
In the bathroom.
he pushed me towards the ground, towards the railing that I mentioned hit Bennett, where you can see in that photo, Bennett hit his face.
Where did that start?
Right at the bathroom.
All right. I know I just said I was going to let this play, but this is a question I've wanted to ask someone for a while. If you depose a witness, why call them as a witness to the stand? So you ask all your questions under oath in deposition. Why do you still have to call them to the stand? And if it's a jury trial, I get it. But if it's not a jury trial, why do you still have to call them to the stand? Isn't everything they say under oath, and you can just submit whatever motions you want based on what they ask? Depositions just kind of seem weird to me unless it's a settlement. I don't know. It seems like a waste of time. It really does to me. But I'm not an attorney.
So he pushed you, and how many feet would that have been?
From the bathroom to the ledge is maybe 2 feet, 2.5 feet.
And isn't it true that he was trying to exit the bathroom and you were in the way?
No,
And isn't it true that you first grabbed his genitals
no,
and you squeezed them hard?
no,
Isn't that true? You did it over and over repeatedly?
no,
You didn't? How many times did you grab his genitals?
once,
And you held them?
no,
Did you squeeze them?
yes.
Was it your intention to cause him pain?
My intentions were to get him off of me.
And that was by
What's up? You guys miss me? I know you missed me. Sorry. No idea what happened. No idea what happened. Um, I do know what happened. My power flickered. It just went boop, and it was off long enough where everything just restarted. So I had to wait to come back. It did happen earlier today when I was talking to Heather. It was out for it. It did pretty much the exact same thing. It took about 2 minutes to come back, and that's all it was. So let's hope I can find where we were quickly. Oh no, I do that every time. I open the video as a media player instead of actually just opening the video on. Here we go. Let's go. All right, let's see. I had 48 minutes before it cut off. Hold on. Hopefully this is right. We were talking about grabbing genitalia, right? That's where we were. That's where we were. No storms. Overnight last night, yeah, we got a kind of a wild random storm overnight, but it's been clear and beautiful today. It's actually been pretty cool. I had to turn my AC. I turned my AC off for half the day today. It's been a random like 72-degree day, and it's been in almost 90 degrees for the last week. So kind of a weird random cool day. Hold on. I think this might be close.
He hurt one of his children. She can guess at that. But it is a guess. You're right. It is speculation on her part. So the objection responds to that, but I understand the question. Do you have a response? I'm going to sustain the objection because it is speculative, but she can answer the question. She can tell what she thinks whether
It's true.
okay.
All right, sorry. I'm trying to find exactly where it was. I had 48 minutes written down, but I don't remember what question they're talking about. I think I'm just gonna let it play. If you guys think, yeah, I know, I think I may have. But I swear I wrote down like 48:13. I didn't write it down. In my head, I had 48:13, and I just went to that, and that didn't seem like that's where I was.
And it doesn't sound like that was intentional on Eddie's part, was it?
Absolutely not.
Absolutely not. You agree with me or not?
I do agree with you.
It wasn't intentional.
Correct.
That was just sort of the byproduct of whatever was going on between you and Eddie, right?
Yes.
And you know Eddie would never hurt Bennett, right? Intentionally.
Objection, Your Honor, that calls for speculation. There's no way for her to know that.
She can tell what she thinks whether Mr. Bregman would intentionally hurt one of his children. She can guess at that. But it is a guess. You're right. It is speculation on her part.
Am I still? Did I still overshoot it? We were talking about her grabbing his balls, right?
Movement.
Okay, and you're looking at the ground as you testified earlier?
At one point, I was looking at the ground. I am
And
doing.
I'm sorry to interrupt you. I don't mean to do that. Will you finish?
I was saying I was doing all that I can to get him off me.
And at that point, at what point during that do you see Bennett's face hit the railing?
In the mix of the tussle.
Okay. But it doesn't sound like you were sure what you saw because you needed confirmation that that happened
That is
later.
true. That is true.
Okay. And it doesn't sound like that was intentional on Eddie's part, was it?
Absolutely not.
Absolutely not. You agree with me or not?
I do agree with you.
It wasn't intentional.
Correct.
That was just sort of the byproduct of whatever was going on between you and Eddie, right?
Yes.
And you know Eddie would never hurt Bennett, right? Intentionally.
Objection, Your Honor, that calls for speculation. There's no way for her to know that.
She can tell what she thinks whether Mr. Bregman would intentionally hurt one of his children. She can guess at that. But it is a guess. You're right. It is speculation on her part. So the objection responds to that, but I understand the question. Do you have a response? I'm going to sustain the objection because it is speculative, but she can answer the question.
You can answer.
Please say it again.
I noticed that too. When I lean back, I'm swimming in the Ohio River. which I don't recommend for anybody. Don't swim in the Ohio River, at least not around Cincinnati. It is not clean. Maybe yeah, you know what? I just wouldn't swim in the Ohio River. Just let's just be fair. But yeah, look, this is cool. Green screen, let's go.
Let's talk about, on May 17th, Eddie had no intention of hurting Bennett, did he?
I agree.
And in fact, he wasn't mad at Bennett on that day.
I don't know his emotions.
The Ohio River has never caught on fire. You're talking about Cleveland, a river in Cleveland, or a body of water in Cleveland caught on fire. Not Cincinnati. Don't compare the two of us. We're far enough. We're pretty far away from each other. We are not the same. I love Cleveland. Cleveland's fun, but yeah, we're not the same. Nope. Don't do that.
Towards Bennett that day.
Okay, but you never indicated to the police that he was mad at Bennett, right?
Correct.
Or that he was yelling at Bennett,
Correct.
or that Bennett was being, not following any rules or directions of Eddie, correct?
Right. Yes.
You're right. You're right. Minnesota, North Dakota, Washington, they're all the exact same too. Every attorney with a beard, the exact same. Exact same, right? Right? See what I did there, my friend?
And then, and you weren't, you didn't injure your foot on that, with that incident, right?
Correct.
And then somehow the two of you separate.
Still in the same space in that photo. We're in the living room together.
At some point you separate, right? The answer is yes. We all know it, but okay.
I just want to make sure I'm answering it correctly. Like separate, meaning we're not touching, or separate like going.
You get up off the ground.
Yes.
Okay. And he walks away from you.
Yes.
And he's in the living room, right?
Yes, as am I.
And you decide to punch him in the head.
Not true.
Well,
I don't know why you're bragging about that. That's why the river is so dirty. It starts in Pittsburgh. Yeah. It is filthy. You guys need to clean that up. There's actual levels of safe amount of sewage in the Ohio River thanks to Pittsburgh. You guys are so good. When The Dark Knight Rises decided to do film their movie in Pittsburgh because it's a dark city. Yeah, there's a reason why. All right. For everyone who doesn't know, Cincinnati and Pittsburgh are kind of rivals. I actually love Pittsburgh. Pittsburgh's a lot of fun. I've been there. My ex-wife's from Pittsburgh. I spent a lot of time in Pittsburgh. It's actually a really cool city, but doesn't mean I can't talk shit. Yins. What does that word even mean? Yins. Mayor, thank you so much. I will be in your area on the 23rd or 24th of September. Okay. All right. Okay. I feel like I should be here. I feel like I should be here during that. I will be spending some time in Canada, but I feel like I will be here for that. So you're gonna have to let me know closer to, or just send me a text, and I'll try to figure out exactly what my plan is. But I think I'm actually gonna be home for that. Awesome.
he's away from you and you hit him in the head, right?
Yes.
You didn't retreat, did you?
I called the police right after that.
After you punched him?
911. No, before.
Okay, but you ran up and hit him in the head in the living room, right?
Not true. I did not run.
Okay, you didn't run, but otherwise the rest of it is true?
I, with an open hand, hit him in the face after I saw blood on Bennett's face.
But you weren't being attacked, right?
That was after I was attacked.
Come on. I mean, at the time you punched him, you weren't being attacked, right? You weren't acting in self-defense. True?
I don't-
Objection, Your Honor, this is
I don't know if
asking for a
that-
legal conclusion.
Yeah, I don't know if this witness can answer that.
Well, I mean, what, because she doesn't know what self-defense is?
Well, because self-defense is a legal argument.
it's a legal argument that is as old as the.
So
As
you
time.
can ask any questions about what happened, but asking this witness to indicate
Okay.
what the legal defense of self-defense is, which is an affirmative defense.
I know what Pittsburgh uses. My ex-wife had a T-shirt that had about 100 different phrases with Pittsburgh geese on it. I know what Gins means. I was joking. I don't know if you're talking to someone in the chat or you're talking to me. But like I said, my ex-wife, born and raised in Pittsburgh, she went to is it Carson Newman? Why do I think that's not the right college? I feel like Carson Newman is that the one that might. Now I'm thinking that might be where my sister went. Yeah, I don't know. Some college in like Pittsburgh. It's a smaller college. Yeah, I don't know. It doesn't matter. But I spent a lot of time in Pittsburgh. I'm not lying. It's a cool city. Just we got a rivalry, so I've got standards to uphold. So I had a lot of fun there, but doesn't mean I can't still talk about it. Beverly, thank you so much for the 29 months. Thank you. Thank you. I appreciate it. Thank you for the support. No. Not Carnegie Mellon. It was two names. It was like a dude's name. It was a guy's name. Robert Morris. I think that's it. I think it's Robert Morris. I think Carson Newman's where my sister went to school in Tennessee. Robert Morris is, I think, where is the name of it that my ex-wife went. Yep, there we go. The chat's delayed, so I said it, then I saw yours. So we may have said it at the same time. That's where she went. Anyways, let's keep going with this clip.
I don't think she can answer that
That's
question.
not what I asked. That's not what I asked.
Well, then
And I don't
ask.
really care about the legal.
She can only answer what you ask, and the ask is what she was there to watch.
I never asked about the legal defense of self-defense. I asked
Yeah,
about
that's exactly what you just asked.
Oh, wait a minute. I asked whether she acted in self-defense, whatever.
That's a legal question.
Hold on, whatever that means to her.
You didn't say that.
Okay.
Okay. So you may rephrase.
How far away was he
When?
when you punched him?
Objection, Your Honor. She has already testified multiple times that she hit him with an open palm, and Mr. Abood keeps
I have facts.
mischaracterizing
I
that
have-
testimony
I
by
have
calling it a punch.
facts and information about this incident, and I
But
don't have to.
then you can provide the testimony.
And-
You said she punched him. Did you punch her?
No,
Okay.
Will you hit him?
with it. As far as when we talk and we're saying I hit him, I want it to be clear that it was with an open palm.
Okay. And you call that a slap and not a punch?
I don't call that a slap.
How hard did you punch him or hit him or slap him? Whatever you want to call it.
I'd call it a hit.
Okay,
Um,
can you stand up?
Your Honor,
She can stand up, but I don't know what the relevance
Okay,
is.
I want to know how tall she is.
I'm about 5'8".
Okay, and I want to see, was he facing you? Do you mind if I approach?
You can approach and
That's why I wanted her to stand up. Can you stand up?
objection, Your Honor, relevance to this whole thing.
yeah, response.
Well, I mean, is this uncomfortable for you?
Don't ask the question. Response.
I want to get the context of it, and she's not doing a very good job explaining it, and it's not with my questions, but she says she punched him. I want to, or
No,
slapped
she
him.
didn't say
or
she
hit him.
punched him.
Slapped him or hit him. I want to know with what effort and how far away she was.
Okay,
And
so
I think-
ask her that.
Well, I think it would be better if I was.
I
able
know
to
you.
sup-
I know what you think, but you can ask her
I
that.
know, I can ask her, I want to know if I could, at least to the extent possible, recreate some of the,
And I'm denying your request to
Okay.
recreate.
did you have to walk towards Mr. Bregman?
Yes, while on the phone with 911.
Okay, and how far away were you when you had to walk towards him?
Roughly 6 feet.
Okay, and how many steps does it take you to walk 6 feet?
Maybe 5 to 6 steps.
Do you know how far 6 feet is?
Just taller than I am.
And it takes you 5 or 6 steps?
I'm not sure.
Did you do it with any kind of pace?
a pace while saying,
I'm not asking you what
no,
you're
no
saying.
pace,
There
no
was no
pace.
pace, you just kind of walked up. Were you mad?
I was calling the police.
I'm not asking you what you did. My
I wa-
question is
I
an
was-
emotional state. I'm asking you if you were mad.
I think there's probably a deeper emotion there than that.
So how many times have you hit Mr. Bregman before?
Objection, Your Honor, relevance.
Goes to self-defense.
I think it's relevant, so I'm gonna overrule the objection. You can answer that question.
I'm not sure.
More than once?
To get him off me? Yes.
So you've hit him in the past more than once. I mean, your answer definitely is, I've never hit him before, right? You can't say you've never hit him before, right?
I have pushed him off me. I have hit him off me
Okay.
before. Yes.
Okay. And so
When he has
Mr.
hurt me.
Bregman would be familiar with those times that you've hit him or pushed him, correct? Been physical with them, right?
He was just familiar with times I had to get him off me. Yes.
And so this isn't the first time on May 17th that you were physical with Mr. Bregman, true?
Again, that I had to.
I get it that you want to say that you were acting in self-defense. Apparently you know what that is now, but this isn't the first time that you were physical with Mr. Bregman, right?
Correct.
And so you took a couple steps and you were acting out of passion because you saw this little mark on Bennett's face, correct?
First, I was saying, get out of my house. I'm calling the police. So I'm kind of walking.
How about just answer my question?
That's so hard. I'm walking towards him while saying, get out. I'm not
Okay.
walking towards him because I see a mark. I'm walking towards him because I'm saying, I'm calling 911. You need to leave. You need to leave.
And
While I am saying that, that's when I see blood on Bennett's
okay,
face.
and now you're mad or acting out of passion, right?
Objection, Your Honor.
So what's the nature of the objection?
Relevance.
Okay. Now you're mad seems to be an argument between yourself and the witness.
Well, I don't care about the mad part. You're acting out of passion, right?
Okay, well, ask that question.
That's what I asked.
That's not what you asked.
I said, now you're mad, and then I said acting out of passion, right? That was the question.
I didn't hear any of the second part of that, but
That's what it was.
all right, objection is overruled, and you can ask her then if she was mad then.
You know what passion is, right?
Yeah.
Okay, you're acting out of passion or emotion,
Yes.
right?
Yes.
And you claim that Eddie is facing you,
Yes.
right? And what I want to know is, did you just walk up, excuse me, you consent to this right now? Did you walk up and just go like that?
No.
No, it wasn't like a little tap with the hand, right?
Correct.
Like your grandma or mom might do to a loved one. It wasn't like that.
No.
Did you say something when you hit him?
Yes.
Like what?
There is blood on his face. He did hit the railing.
Okay. And how far did you cock your arm back?
As a former bartender, yeah, I can resolve this. Get out of my bar. I don't know what's going on here, but just go. Yeah, this attorney, right? I told you. What I remember from this case is the attorney, and that's what I remember. I know it's a DV case, and the attorney is just kind of trying to earn his paycheck really hard. That's what I remember, and how it ends. But I'm not going to tell you that.
Enough to be close to my own face.
Well, I want to see it. So is that the way you held it, sort of?
Let the record reflect you're indicating about 2 inches from your face, 2 to 3 inches.
If I know there's nobody in front of you, but can you just do it like an air swing?
Objection, Your Honor. Relevance at this point. We've already established, she testified that she hit him in the face with an open palm. She has demonstrated for us how far she cocked her hand back. Mr. Booth tried to have the demonstration earlier. This is just another way to try to do that demonstration.
If the witness can answer and show Mr. Bood and the court how the hit went, I'm going to allow this question to be asked. So the objection's overruled. So you can answer the question.
Okay.
That's it? Just sort of, you pushed your hand
Is that a
out?
yes?
Yes, that's a yes. And I did this.
And into his face?
Yes, the side of his face.
What side?
I don't know.
So let the record reflect the witness has placed her hand forward, I'd say about 4 to 6 inches from her body.
I'm not sure about that. I mean, what she did is she demonstrated that her arm was bent near her face with an open hand, and she extended her arm out all the way. Right?
That I don't know. I saw her move her hand forward about 4 to 6 inches from her body. You can clarify the record with your clarification.
Fully extend your arm out?
Yes.
Okay,
All right.
that's what I saw.
All right. So the records still reflect that she's extending her arm or hand away from her body. Maybe it's greater than 4 to 6 inches. I don't know. But the record reflect that she has extended her arm fully concerning this matter.
And then did Mr. Bregman say, "What are you doing?" at that point?
I don't remember.
Okay, and he still had Bennett in his arms?
After I hit him, I also don't remember.
Well, before you hit him,
Yes.
you saw that he had Bennett in his arms. You saw this little mark on Bennett's face, and that's what instigated you to act in passion or emotion, right?
I saw blood.
Yes, we're
Yes.
talking about, did Eddie have Bennett in his arms at that point?
Yes.
Okay, and then he apparently pushes you down at that point?
He throws me down and I fracture my foot.
Well, does he pick you up?
No.
Well, how does he throw you down?
He grabs me and forces me to the ground.
Okay, well, we're gonna go over this in detail. He grabs you with one hand or two?
I don't remember.
Do you know if he was holding Bennett the whole time?
I don't remember.
Do you know whether you tripped?
I did not trip.
Did you get airborne? Meaning, did he physically get you up in the air and throw you?
No.
Okay. Was it similar to what happened in the hallway where he pushed you to the ground?
Similar but not the same. More aggressive and
Okay.
more forward because there's more space, as you
Okay.
alluded to in the picture.
And do you know whether your foot hit anything?
No.
Do you know what caused your foot to break?
The force of going down from Eddie forcing me to the ground.
So your foot hit the ground?
Yes.
But you can't tell the court how he grabbed you, whether you grabbed your left arm or right arm or.
I do not remember if it was my left arm or right arm during this instance. It could have been both. If he set Bennett down, I don't remember.
And he didn't punch you.
He did not punch me.
He was just trying to get you away from him.
Objection calls for speculation.
I'll rephrase.
Okay, with that, you don't have to answer that question. The attorney's going to rephrase the objection sustained.
Did it appear that he was
Overruled.
just, I'm sorry,
Sustained, it's sustained.
did he appear he was just trying to get you away from him?
No.
Oh. But he did get you away from him.
After I extended my arm, I was away from him.
Oh, how far?
2 feet,
Okay, so
roughly.
2 feet would be approaching this close,
Yes.
within a step that you could punch him again,
Nope, I did not punch him.
within a step that you could punch him again. I understand you didn't, but you could have.
I could have reached out my arm again.
Yes. And he gets you away from him.
All right. The attorney aside, the body language of the defendant right now. First off, I am happy he wore a suit. He's taking this serious, right? He is laid back and he looks like he's just enjoying this defense attorney tear apart the mother of his children. I don't like that. I am not the biggest fan of my ex-wife. She is still the mother of my children. I wouldn't put her through this. If she accused me of assault on her and I was going and I had to go to court, I don't know. I think I would take a plea deal. Unless it was just flagrantly false. I don't know. Um, I don't like the idea of anybody talking to the mother of my children like this. I'm sorry. Again, I'm not the biggest fan of her, but I will still defend her. Just yeah, I don't. This is making me uncomfortable. Is this making anyone else uncomfortable? I'm sorry. I think I'm venting a little bit. And anyone who's ever heard me talk about my ex, especially on Discord calls, I'm not really the nicest person to her, but that's me. I'm allowed to do that. No one else is though. No.
right?
I feel as though I was already away from him.
Yes, you were 2 feet, but he gets you more away, right?
He threw me down.
Okay, and he doesn't punch you when you're down, right?
No, that's when he grabs the phone.
Yes, he's not on top of you.
Correct.
He leaves you alone,
No,
he walks away.
no, he grabs the phone.
Okay, where's the phone?
Well, it was in my hands until he threw me down.
Okay.
It fell out of my hands. So it's
Okay.
on the ground.
So he's away from you. He
Um,
grabs the phone and he
then-
walks away.
Then I'm asking for them to come, so I don't remember if the phone was in my hands or on the floor, but it was right into my back, close enough to be on my less than 4 inches from me, and that's when he walked to me
Okay,
to grab the phone and said something along the lines of everything is fine,
and,
and he hung up.
okay, and then what?
I'm crying on the floor.
Doesn't
holding my
touch
head.
you at all, right?
Correct.
Objection, Your Honor. He needs to let the witness finish her answer. He asked, and then what?
I'll overrule the objection. This is cross-examination.
I'll give her a chance to answer it. But doesn't touch you. Tells the people on the phone everything's okay, according to you, right? You're lying on the ground still,
I'm sitting on the ground.
so you sit up?
I'm sitting or laying. I have no recollection. Maybe I'm
Okay.
on my hip.
And does he walk away?
First, he walks towards me to grab the phone.
Yes.
Then he walks away.
And does he take Bennett?
Yes, I think he takes Bennett downstairs.
Okay. And then, and then whatever you're doing, you have your phone and the police come, right?
The police call back.
Okay,
Because
but
Eddie
you
hung up
and
on me.
Eddie have no more interaction.
That's not true either.
Okay,
Lots of interaction.
okay. Is he down the basement?
He comes upstairs from the basement and keeps telling me, I have a chance to tell the police that everything's okay. I have a chance to make this right. I have a chance to not make this worse.
Okay, he doesn't touch you at any point during that time.
No,
And do you know where Bennett is?
downstairs,
And where's Baylor this whole time?
sleeping in bed.
Okay, I mean, you don't know that he's sleeping, but you don't hear him crying, right?
We have a monitor.
Okay. Does the monitor have a video?
Yes,
Okay. Did you check on with Baylor?
while I was waiting for the police. Yes,
Okay, so the entire time Baylor is sleeping.
yes,
That's interesting.
I agree.
Were you drinking that day?
Objection, Your Honor. Relevance.
It goes to perspective of each party's perspective, so I'll allow it. Objections overruled.
I had poured myself a glass of wine.
What time?
Was 7-ish. I would have to confirm with when I called the police and then take about 30 minutes off of that.
So, and what kind of wine was it?
Red wine?
Okay, and do you have a heavy pour?
No.
Was it a normal wine glass or what kind of glass was it?
I will send the defendant or the witness $100 right now if she says it was a mega pint of wine. You jackass! Who the fuck cares? Sorry. That just slipped out. I am sorry. I do honestly try not to swear too much. Sometimes my emotions get the best of me. I just wanted to make the mega pint joke, and yeah, now I've taken it too far. Sorry, guys.
I don't remember. I think it was a normal wine glass.
Did you drink it?
By that time, I think I had about one sip because I had to take care of Baylor first.
So you're saying you consumed a sip of wine?
Say that again.
You're claiming you consumed about a sip of wine.
Yes.
Did you drink anything else that day?
No.
Are you on any medication?
No.
No prescription or non-prescription medication of any kind?
Correct. I'm not on anything.
Do you do any kind of recreational drugs?
No.
Like marijuana, which is legal?
No.
I do. I care, and that's all. That's all that matters. I try not to. I feel like swearing is okay if used correctly. What I just did right there, not really used correctly. That it showed a lack of intelligence. I could have used 100 different words, but I went to that. So I care. I try to use my words correctly, and that's why I say words are hard because I do try to use them correctly. But yeah, I do care.
Can I have a minute?
Ask Ms. Fortuna Gill.
I'm sorry, what's that?
She just wants water. So let the record reflect the witness is being given her water, and Mr. Boot is consulting with one of his attorneys.
Let the record reflect that he probably should just be done. I don't know what else he can.
Eddie was coming upstairs and talking to you. Were you still on the phone?
Don't remember.
What about when you had 911 on the phone? Was Eddie yelling at you?
Yes, I think so. But
And what you told 911 is to come to the house,
yes,
and they did come to the house.
yes. It took them roughly 45 minutes to an hour.
Guess you take that up with LPD.
I share that because during that time, that's when Eddie kept coming to me.
Is there something wrong with that?
A lot of yelling, verbal abuse.
That's what,
He has a right to do.
yes. You don't like that, though.
I don't like to be verbally abused.
I don't have any further questions.
Redirect Ms. Fortuna Gill.
Your Honor.
I would love everything that he just said is bullshit. I know I've already sworn once. I might as well just keep it going. Thank you so much, Skittle. I appreciate it. I'm not going to say your name, but I'll call you Skittles. Official seal of approval for Pappy Collins F-bomb. I appreciate it. Thank you so much for the super chat.
May this witness be excused from the prosecution?
Yes.
May this witness be excused from the defense?
Yes.
Okay, thank you for your appearance, ma'am. You're excused. The people may call their next witness.
Your Honor, the people rest.
All right. Does the defense have any proofs today, Mr. Booth?
No.
All right. Motion for bind over Ms. Fortuna Gill.
You don't do that.
Yes, Your Honor, my apologies. Today, the people are moving for bind over on count 1, interfering with a crime report, the 10-year, as well as interfering with electronic communications. That is the 2-year. The people would also ask for bind over on child abuse 3rd degree. The people also wish to add the charge of aggravated domestic violence. I understand that's a misdemeanor, so we of course won't be moving for bind over on that, but we will be adding that misdemeanor charge.
What is the, what's the tax code on that?
Yes, just one moment. My apologies, Your Honor. The PAC code is 750.81A2.
And then arguments on counts 1 and 2.
Yes, Your Honor. So on counts 1 and 2, first is count 1, preventing a crime report. The people need to prove first that the defendant prevented or attempted to prevent Miss Paris from reporting that the defendant's conduct. We heard testimony today from one witness, Jacqueline Paris. She had indicated that she did call 911 after she was shoved to the ground by the defendant to report that, and that the defendant did grab her phone and in fact tell 911 that everything was fine and they didn't need to come. The second element of that charge is that the defendant used physical force when preventing or attempting to prevent Miss Paris from reporting that crime. We heard testimony today that there was a second shove to the ground or a second grab and push to the ground, and that he had grabbed the phone from her while she was being restrained. That would satisfy that second element. The third being that the defendant's use of force involved committing or attempting to commit a crime. The crime being aggravated domestic violence here, as well as telephone interference. And I will go into how and why both of those are charged here. As for count.
So what are the facts related to count 1? My understanding is that she was able to report the crime that was committed, and then I believe the phone was broken.
The phone wasn't broken, is my understanding. The phone was grabbed, and then the defendant told the police that everything was fine and they didn't need to come, thus preventing the completion of the crime report. And then there was so much so that 911 called back. The telephone interference is count 2. The people need to prove first that the defendant prevented, obstructed, or delayed by any means the sending of an authorized communication through a telephone. We heard testimony today that the defendant did hang up that phone call while Miss Paris was communicating to the dispatcher about what was happening. The second element is that the defendant did this willfully and maliciously. This means the defendant did the act on purpose and with the intent to prevent, obstruct, or delay the communication. We have the defendant's statement, which I believe goes to his willfulness to have this call hung up. He tells the police everything's fine. He later makes statements to Miss Paris that he can make everything okay, that the police coming will make everything worse, things of that nature. And
which leads me into a great segue for any of those grammar nerds out there who really enjoy watching grammar related content. We have a great friend of the channel. His name is Grammar School. He has a great channel. Go check him out. Am I back? Am I back? Hi, I'm here. I just got the spinning wheel of death. I think we're okay now. All right, we're good. I didn't get kicked out. I didn't get kicked out. I think we're good. I'm gonna rewind just like 10 seconds. I think I caught when it cut out. So let's go.
everything okay, that that the police coming will make everything worse, things of that nature. And these crimes are similar in nature, but they are different. So the main purpose of interfering with their crime report is just that, preventing a person's ability to report criminal conduct. And then interfering with electronic communications isn't necessarily related to criminal conduct, a criminal conduct report, but it is just the interfering with some sort of electronic communications. Under the Blockberger same elements test, each offense does contain an element that the other does not.
Mayor also has a great channel. I'm sorry, Mayor. I'm sorry. I just thought it was a great segue into shouting out grammar school. We're talking about grammar in the chat. Mayor does have a great channel. Go check out Mayor. And Mayor, you don't need me to shout you out. Unlike grammar school, you have a wrench. You can drop your own link. Mayor does have a great channel though. Everyone go check him out. Sorry, Mayor.
So what is the name? So what is the facts leading up to count 2?
Yes, Your Honor, the facts leading up to count 2 are the same facts, the hanging up of the phone call that Ms. Paris was making. So it's the same facts, but different elements. So for example, interfering with the crime report requires unlawful physical force. There's no physical force required out of electronic communications. Additionally, electronic communications does not require a crime report. It just requires the obstruction of electronic communication, being the phone call. The count 3 that the people would move to amend count 3 from misdemeanor 4th degree child abuse to a felony 3rd degree child abuse. The elements of that are that the defendant, or first, that the defendant, Mr. Bregman, is the parent of the named child. Bennett, in this situation, the 2.5-year-old child that Ms. Paris and Mr. Bregman have in common. We heard testimony today that he is in fact the father of that child. Additionally, the defendant either knowingly or intentionally committed an act that under the circumstances posed an unreasonable risk of harm or injury to Bennett, and the act resulted in physical harm. So while we
sorry, everybody. I am sorry. Now it's giving me the alert that I just joined the studio. Yeah, thank you. All right. So remember when I told you guys, I don't know, 3 years ago that I don't jump on video because this is what happens when I go on video. My internet sucks. I actually don't think that's what's going on tonight. My power keeps flickering. No, the little internet dip, I don't know, like 10 minutes ago, that was weird. That was random. That honestly could have been because I've been on video, but but my power's been dipping in and out tonight. I didn't grab a time. It dropped so quickly that I wasn't even able to grab a time for where we were. But I know we were in closing. Let's try right here. Hopefully this is right. Guys, I am so sorry. Thank you so much for hanging out. And Legal Fiction, thank you so much for the onion super chat. I bet you thought I would miss that because you sent it when I was, in the abyss of the internet, but I did not. All right, let's try to finish this up. I wanted to do this all in one night, and now we're close to 2 hours, and so we need to finish this up. But like I said, I don't have a timestamp, so hopefully we're close.
So I believe all the elements are, oh, I apologize. Third, that the named child at the time was under the age of 18. We heard testimony that Bennett is 2.5 years old.
So I'm a little confused. The
Yes,
child
sir.
abuse fourth, you're asking for a different charge
We are asking for a child abuse third,
based on the relationship.
based on the physical injury. That's what differs the charges. Because there is a physical injury to Bennett's face. So it would be amended from 4th degree to 3rd degree, which would make it a felony.
No offense, Specs. I'd be bored if I were you too. If I was wanting to watch a video and this random dude that I've never seen before is now on video and keeps pausing the video and and his power keeps dropping. I don't know. I don't know what I would think either. Such a great show tonight. So good. So good. You guys are awesome.
And would require bind over by this court.
And then count 4 is the assault, aggravated domestic assault,
That is correct, Your Honor.
and that is a 1-year misdemeanor.
That is correct.
I'm just making sure I understood. the counts.
Absolutely.
Okay, then the argument.
Just additionally, the people have satisfied location, that this occurred at their residence, which is at 2410 Robinson Road. That's in the city of Lansing, County of Ingham, State of Michigan, making this court appropriate venue. The date was satisfied as May 17th of 2026. ID was successfully completed by the witness. And so the people do believe that all of the elements for the crimes as charged, count 1, 2, and then the amended count 3 have been met to a probable cause standard, as well as location, ID, venue, and date. And the people would ask the court for bind over.
Response, Mr. Abu.
I mean, I don't remember any testimony about the child being cut. She saw blood and she testified, and that's why the question was asked. You weren't bleeding, Eddie wasn't bleeding, so they want the court to draw an inference that the child was bleeding. There's no evidence on this record of the injury. There's no evidence on this record of medical treatment. In fact, the testimony, there's no testimony that anything he did to the child was intentional or that it was directed. It's still a specific intent crime that you have to show.
So that's the child abuse third. That's the argument on the count 3.
Yes, yes. And I assume by you sort of cutting me off, maybe you got this figured out. But the idea on this record that you could find that there was child abuse, God have mercy on anybody who's a parent, because this kind of thing happens on a regular basis with no intention of hurting your child. Sometimes children are in the mix. But the other part, going to count 1, interfering with report of a crime, which is a 10-year, through the unlawful use of force. And that's the question about what happened here. What was she gonna report? She indicated that she just told the police to come to the house. She didn't report a crime on the phone. And she is the instigator of the physical. I mean, she assaults him with the water. He's leaving, and she claims he grabbed her arm first. Okay, but there's what I would call a physical tussle between the two of them. She admits to grabbing his genitals, and so to that extent, I don't think they satisfied count one. And with my understanding of the evidence, the way it was presented here, is she's on the phone. She assaults him with the slap to the face, or slap or hit. He pushes her away. She's 2 feet from him. He pushes her away. She falls to the ground. That's when the phone is out of his hands, her hands, and he picks up the phone and tells them everything is fine here, or something to that extent. So I don't think you can say that the second push or fall was not in self-defense, in which the injury occurred. And for that reason, I don't think you can't satisfy count one with the second push. And it's not satisfied from the first incident where they're tussling. She's in the doorway. She throws water in his face. She admits she's acting emotional. Under those facts, to bind him over on a 10-year is not, it hasn't been satisfied from these proofs. Thank you.
All right, thank you. Response, Ms. Fortuna Gill. Again, clarify me for once again the difference between counts 1 and 2. The count 1 being the 10-year and count 2 being the 2-year.
Yes.
I'm using the count 1. The theory of the case is that the defendant told 911 that there was nothing here. There was nothing here to go on. Count 2. What's the theory of count 2? Is it the same actions?
It's the same action, Your Honor.
I appreciate that, Specs. I'm in my head a lot, and it's an unfortunate part of being a YouTuber. I'm in my head. Every video I post, I'm in my head about, do people like this? Do people like me? Are people going to watch this? It's the unfortunate side effect of being a YouTuber. What you said earlier, I was joking with you because I thought it was funny. So I'm not in my head about what you said. I do appreciate the super chat. Thank you so much. But yeah, I'm not in my head more than other YouTubers are. I don't think. It's just a unfortunate consequence of being on the internet. And I've got 25,000 subscribers. A lot of people watch my stuff. Get a lot of negative comments. So but more positive than negative. So that's always good. But no, I appreciate you, man. Yeah, everything's good. I'm fine. If I wasn't, I wouldn't be on video. I actually got up to go to refill my water a second ago and went to the bathroom and forgot to fill my water. So that's awesome. So yeah, but I don't know why I had to say that. I like talking.
So it's the same action, just different elements. So that's why both are charged. As well as with the interfering of the crime report, it does require unlawful use of physical force. So that would be the second shove, which causes the phone to fall out of Miss Paris's hands, as we heard testimony of today. And then Mr. Bregman grabs the phone after. I believe she testified it was maybe 4 feet. No, 4 inches from her face.
That was after
The shove.
Okay.
I did want to clarify for the record that what Mr. Abood said, that she didn't report the crime, that's true, because he interfered with the crime report. So she was never able to actually report what crime happened. She told the police she needed them to come. She gave them the address, and then she's grabbed and thrown or shoved to the ground with force. The phone falls out of her hand at that point, and that's when Mr. Bregman grabs the phone and tells 911 that they don't need them to come. Additionally, I wanted to talk about the child abuse third. Nobody here is making the argument that Mr. Bregman intentionally injured their child. The argument that I'm he intentionally put his child at unreasonable risk of harm or injury. And the way I understood
Yeah, but I think the law that you cited, which is I will give props to the defense attorney when it's due. What he was just arguing was what you just tried to charge the attorney with was, or not the attorney, the defendant was that it was he had intent. You know, like if you're spanking your child and you leave a bruise, not saying not saying that's okay. I'm just saying, but you had the intent to spank your child and you went too hard. And I think that's what that attorney was arguing. Like, there's no way he didn't do that. I think that's what the attorney was arguing there. So, yeah. Anyways, legal fiction. Thank you so much for the 10 gifted memberships. I appreciate it. Welcome to the 10 new members. That's 20 from you tonight, legal fiction. Thank you so much. I appreciate it, bud. I appreciate it. Dr. JD. Thank you so much. I come for Colin's hold on. Contentment and stay for the chat. There we go. Contentment. I had to practice that word a little bit. Dr. JD, good to see you tonight. Thank you so much for the super chat. And Alan with the 5 gifted memberships. Thank you so much. I appreciate it. Welcome to the 5 new members. I think we have 25 tonight. 20 from no, well, I gifted 5, but my 5 don't count because they're free. No, it's why I always shake my head when people say thank you to me for the like. No, they're free. Like, YouTube gives me 10 to give away. I usually give them away on the 1st and the 15th, but members Monday tomorrow night I can't give them away, so I gave away tonight instead. So 25. Well, I guess again 30 counting mine. 30 new members. Hopefully we'll see you guys tomorrow night for Members Monday. It's always a good time. Always a good time.
proofs was that there was a cut or a laceration. I don't remember the exact words that Miss Paris used to his face, that she saw that, and then she saw that he was bleeding. And so that would be the physical harm satisfying the second element of the child abuse third. And I would argue these things don't happen all the time. You don't hold a child while you assault your partner. That puts that those circumstances certainly pose an unreasonable risk of harm or injury to that child. This isn't a playground accident. This is intentionally deciding to assault your partner and that child's mother while you have that child in your arms. So I wanted to make those clarifications and again ask for a bind over on count 1, 2, and count 3 as an amended child abuse third degree.
All right, thank you. The standard for preliminary examination is probable cause. Probable cause being one of the lower standards in criminal law, reasonable suspicion being the lowest standard. I find that the location of Robinson, it's 2410 Robinson Road, has been met at a probable cause standard. In the city of Lansing, Ingham County, state of Michigan, so venue has been met. The date of May 17, 2026 has also been met at a probable cause standard, and the defendant was identified as the person being in the relationship and being the same person who sat in the courtroom, so identification has been made. The elements of the crime as to count 1 reads, did through the unlawful use of physical force prevent or attempt to prevent another person from reporting a crime committed or attempted by another person.
Specs. The best way to support all the channels is just watch, hit the like button, and just give the view time. That's the best way to support channels. That is the most that helps channels grow. Leave a comment on videos. So live chat helps with engagement while the chat's going, but when the video's over, the chat doesn't matter that much. It really doesn't. But comments on videos help. Like button helps. The subscribe button is kind of kind of misleading. How many subscribers you have doesn't really matter all that much once you hit a certain point. So, just watching videos, liking videos, leave a comment. Even if you don't really have anything to say, just leave a comment and say, hey, I really enjoyed this. Thank you for your hard work. That's all you need to say. and you'll get a thumbs up from the creator. That's honestly the best way you can support channels. That's all you have to do.
And the violation involved committing or attempting to commit interference with the electronic communication. I believe at a probable cause level, it's been shown by the witness that count 1 has been proven by a probable cause standard, in that the defendant grabbed the phone or had the phone and indicated to 911 that there was nothing going on there, and there was obviously some type of fray or tussle going on. I'm uncertain what that is. That's for the trier of fact to figure out. But that's been proven at a probable cause level, so count 1 is bound over as charged. Count 2 reads, did willfully and maliciously cut, break, connect, disconnect, interrupt, tap, or make an unauthorized connection with a telephone or telephone line? I don't believe that count has been made at a probable cause level. And so count 2 is dismissed. That seems to be more of the count 1, and count 2 seems to be the similar activity, but there was no breaking, cutting, disconnecting, interrupting, or tapping the telephone line. What it appears to be is count 1 seemed that the defendant took issue with what had just happened and said, this is not the same occurrence. So count 2 is not bound over. Count 3, which is the child abuse in the 4th degree, was issued, will follow as on or May 17, 2026 at 2410 Robinson Road. The defendant did knowingly or intentionally commit the following acts, and that's an assault, under the circumstances posed an unreasonable risk of harm or physical injury. I didn't get any testimony as to the nature of the injury of the child or risk of harm. There may have been blood. There may have been a scratch on the child, but there's nothing to indicate the nature of that. So child abuse 4th is follows, but child abuse 3rd is not bound over as a felony. It'll be as the child abuse 4th felony. It'll be child abuse 4th, which is the 1-year misdemeanor. And then child abuse 4th is added. I'm not child abuse 4th. Count 4 is added as domestic violence concerning this matter. There does appear to be that there was a tussle, that there was a fray. We'll let the trier of fact figure that out, but that does fall as domestic violence. It does appear there was an injury that was reported to happened as a result of this.
No, it's not with prejudice. The prosecutor has they can recharge it with different evidence, but it's not likely. If the court finds no probable cause, they're gonna have to go and really make an effort to recharge the case again. But no, generally, I mean, usually the judge will say with prejudice or without prejudice. So we might hear that here in a second, but no, with lack of probable cause does not necessarily mean it's with prejudice.
And so I will bind over, count 4 falls under 750.814, I believe, as a domestic assault. Did occur, 750.81A2 did occur. So counts 3 and 4 will follow as misdemeanor counts. They're both 1 years. Count 2 is not bound over. Count 1 is bound over on the 10-year. So that's the ruling. The court, count 1 is bound over, count 2 is not bound over, and then count 3, and we'd add a count 4 of domestic violence, aggravated assault, the 1-year misdemeanor, and that will follow the count 1, which is bound over. So I will indicate for the record that a preliminary examination was held on today's date. That is June 5th. And we've amended the charges, so count 1 is bound over. Count 2 is not bound over. And counts 3 and added count 4 of domestic assault, aggravated domestic assault, will follow. Count 3 and 4 are misdemeanors, and so they're not a part of the bind over decision. That comes under, I have 750.8. Is it 750.811A2?
Is.
81A2 or 8811A2?
It is 81A2.
All right, so bound over on count 1, not bound over on count 2, and then counts 3 and 4 will follow. So Mr. Bregman, your time in district court is done. You're off to circuit court. You'll get your next date of appearance from your attorney, Mr. Boot, okay? All right, anything else for the record in docket 2601-352, Ms. Fortuna Gill?
No, Your Honor, thank you.
Mr. Boot.
Bond?
Do you want to be heard on bond, Mr.
Yes.
Booth? You may be heard on bond.
Court has heard
Before
that the
I was wondering why there was still 10 minutes left of this video. We got a bond argument now. All right, fair enough. Let's go.
defendant is the father of 2 children. One is Bennett, the other one is Baylor, 2.5. Bennett is 2.5. I think that the evidence is clear that there was no intention to cause any harm to Bennett. He has no criminal history. The idea that he could be prevented on these facts from seeing his children and spending time with them. Until today, there was no domestic violence charge, but he hasn't been in contact with Ms. Paris. So it seems to me that for purposes of parental visitation, he should be able to have contact as far as pick up and drop off, and to be able to continue to exercise parenting rights.
I'm trying to make it look like the river's floating my head away, and then it disappears in the corner. That's what I'm trying to do. I'm having way too much fun over here.
All right, so Mr. Bregman has a 2,000 PR bond. This is a bond modification request to see, and is there a no contact order on both
Just Bennett.
children? Just Bennett.
And there was
4.5
there was
years.
not a no contact,
On
2.5
Baylor.
years with Ms. Paris, but I assume the court's gonna institute one because of the,
Yeah, I have a no contact with Jacqueline
oh,
Paris.
maybe you do,
Yeah.
maybe you do.
All right, Ms. Fortuna Gill, bond modification.
Your Honor, the people have no objection to Mr. Bregman seeing his 2.5-year-old child. The people are in agreement that
Heather, you walked into my head floating down the river. Here, look. See, look at what I can do. Look. And then I fell underwater. I'm having too much fun. That's what you walked into.
certainly there was no intention for Bennett to be harmed. The complaining witness also is completely amenable to Mr. Bregman being able to see his children and there being some sort of third-party contact to make that happen.
All right, so I'm gonna indicate that Bennett Bregman, and I think we're talking about the 4.5-year-old, is not a part.
2.5.
2.5. Bennett is the 2.5. Baylor's the 4.5.
Baylor
4
is
months.
6 months.
6 months.
Or yeah, now.
5 months.
All right, so let's remove Bennett Bregman from the no contact order. Is removed from the no contact order for the purposes of the duration of this file. So we'd make any third party, so that was third party there would be a third party present during any meeting with Bennett. I don't see Bennett being a witness.
I'm sorry, you're saying it's supervised visitation?
Well, I guess I
mean, I can understand on the pickup and drop off.
yeah,
But
I can only in regards to pickup and drop off. I don't want to get into the discussion. I'm lifting the no contact order, and then as far as picking up and dropping off, I think third party contact is a necessary evil of that.
But if he picks up the kids and goes to the mall or whatever you
Right.
do with the.
It doesn't have to be supervised.
Okay.
Yeah.
okay.
I just want to keep him so if he's contacting someone to pick up or drop off, he doesn't get violated. Yeah, that's the only nature, because they'll violate you for contacting Miss Paris, direct or indirect. And if you, so I don't want that to happen. Okay. Yeah, so I'm going to indicate that third-party contact is allowable for drop off and pickup. If you have to go through a third party to get to Miss Paris, that's allowed. Okay. And then we will pull Mr. Bennett Brengman from the no contact order. Orders lifted.
And there is no contact with Baylor, obviously.
I have no contact with Baylor, but I'll double check just to see.
I just don't want there to be a misinterpretation,
Right.
because you haven't taken any action as to Baylor.
Right.
That doesn't mean that when he goes to.
I have no contact. I don't have Baylor on the no contact list.
Right, okay.
I have Bennett and Jacqueline, and I'm removing Bennett. So only Jacqueline is part of the no contact. I also.
And he can do indirect contact with.
Correct.
Ms. Paris regarding child custody issue.
Correct.
And
so you could get somebody to contact Ms. Paris to allow to say, I'm picking him up at this time and dropping him off at this time.
She has all the right to when and where and how, correct?
Well, as long as it's okayed, you have your probation won't be violated for the indirect contact. Okay. That's the plan. All right. Anything, so you'll get your next date in circuit court from your attorney, Mr. Bood. Anything else for the record in 2601-352, Ms. Fortuna Gill?
Not for the people.
Mr. Bood.
Nothing.
All right. You're all set,
Thank
Mr.
you.
Brennan. Thank you for your appearance.
Thank you, Your Honor.
Jake Wellen, you done messed up, AA Ron. So one of the best skits of all time. All right. That's it. That's all I got. I know we had a lot of delays tonight. Hopefully my power stops flickering. And maybe no, I'm not gonna jinx it. Not gonna jinx it. You guys are awesome. Thank you so much for hanging out with me tonight. I know this was a little bit longer of a case, and we got delayed for about 20 minutes because my internet just loves fun. So yay! But you guys are awesome. Thank you for the super chats, gift to membership milestones. You guys are awesome. And mods, thank you so much for hanging out. No. Why are words so hard? See, after 9 o'clock, I don't think words should count for me anymore. Everything I say after 9 o'clock, just don't even listen to me. Whatever. Mods, thank you so much for your hard work. That's what I wanted to say. All right. Now, who we're gonna raid? we're gonna raid somebody. I'm gonna guess it's Lone Wolf. He's probably the only one on. Germinger's on. We raided him the other night though. We'll go to Lone Wolf because Lone Wolf does court. Germinger's awesome. He has a gaming channel. If anyone wants to go watch him play Elden Ring, go hang out with Germinger. I know he would appreciate it. I do like to raid people in the with similar videos, right? So it helped. I don't know. I love Germinger though. Germinger is awesome. I don't know what I'm saying. Again, words don't count after 9 o'clock. Have a great rest of your night. Go tell Lone Wolf I said hi. That's all I got. Thank you. Members Monday tomorrow night. Hopefully I'll see you guys there. Goodbye.
And then Mr. Sil